I do, and I've read it, and I'd waive reading. I'd note the address is correct, except that Mr. Wilson is in the Dane County Jail on a revocation hold. So I think we should use the Dane County Jail for his address.
All right, that's fine. I do know he is on that hold. It looks like he may have a pending misdemeanor case assigned to Judge Taylor. So we'll get this case. Yep, we'll get this case assigned to the same judge. Mr. Wagner, your position on bail?
Your Honor, the state's asking for $5,000 cash bail. The defendant was on extended supervision whenever he sold fentanyl to the person who's deceased in this case. He's got a long criminal history with many prior convictions. Many of his failures to appear are pretty old, considering because he's had cash bail on most of his cases. So he hasn't been released as a condition of bail. But based on the seriousness of this offense, I believe that cash is necessary. We'd also ask for the condition that he have no contact with the person with the initials SLB, and that he also not use or possess any controlled substances or drug paraphernalia without a valid prescription.
And just so I have the chronology of things correct, if I read the complaint, it appears that this is alleged to have happened in April. Does that precede him being on bail in the other misdemeanor case then?
Yes.
All right, and I accept that there's no bail jumping charge that's listed,
Sure.
So that makes some sense. All right, thanks, Mr. Wagner. Mr. Eisenberg, your position.
Your Honor, this offense happened 10 months ago. I read the complaint. I find it very weak on identity. I note that there's a phone from 10 months ago and a phone from 4 months ago, and that's how they're trying to link up Mr. Wilson, because the phone number may be linked to him. Anybody could have used anybody's phone. What is further bothersome is when they identify the defendant, the individual, I am sure, SLB, and I assume I'm going to get the names of all of these people that are listed by initials in this complaint from the district attorney's office. I assume they provided her or him with a photo array to her. And obviously, she did not identify Mr. Wilson as the alleged perpetrator. So I find the allegation of a sale of something 10 months ago does not support a bond of $5,000. As everyone knows, Mr. Wilson is the individual who was shot on February 3rd by 2 white police officers. And now, and this is a Dane County case, this is not a DCI case. And now, 10 months later, everybody's running to the court to file this. What's been going on for 10 months? It's very disturbing. So I don't think cash bail is necessary. I think the identification is extremely weak. I think the complaint is extremely weak. With that said, Mr. Wilson is currently on a hold, and on today's date was served with revocation papers. So I think number one, bail is redundant because he's already going to be on a hold and facing revocation. Number two, I would request a cash bail of $100, and the question is why? Because of State versus Hintz, H-I-N-T-Z, which I believe may allow, well, does allow for credit for both this offense, should Mr. Wilson be convicted, and the revocation hold. And I am not sure whether a actual cash bail is required to invoke the credit for both offenses. So I see no reason for $5,000 cash bail. The recitation of a lengthy history of convictions, I think lengthy is overstated. He is, I think, eligible for release on his own recognizance, although we know that's not going to happen. So I think $5,000 cash bail is not necessary. I think $100 cash bail to protect his rights for credit is certainly more appropriate. And then when we look at this, Your Honor, It's $5,000. That's what the state's asking for. If they were in here asking for $500,000, I can understand nobody could ever post that. But $5,000 is not an insurmountable amount, and so therefore I see it as being superfluous. But beyond that, it's just not necessary or required in this case under section 969.01, at least until the legislature may or may not change the law. That's my request, Your Honor. Thank you.
I appreciate it, Mr. Eisenberg, and I know that there's been reference made to him being on extended supervision. Does anyone have information about whether he was in good stead with his agent when taken into custody?
I do. Oh, well, he wasn't taken into custody. You have to remember, on February 3rd, he was slammed in by 21
Right.
cops.
No, I heard your explanation for the circumstances, but at some point he was taken into custody. I'm just trying to.
After he was shot.
Right. I guess what I'm trying to figure out is whether he was in absconder status or whether he was regularly reporting.
No, I get it, Your Honor. He was on GPS for 7 months, and he had a good rapport with his agent, Sarah Grieger. And in fact, he was scheduled to go in to see his agent on the morning of February 4th, Friday, to arrange for a pass to allow him to travel to Illinois for Valentine's Day with his girlfriend. He was in a good relationship with his agent, Your Honor, and on GPS for the last 7 months before he was shot.
All right. Thanks, Mr. Eisenberg. Mr. Wagner, I'll give you a chance to provide any rebuttal.
I don't have any information as to how he was doing on probation in front of me at this point. As Attorney Eisenberg has stated, that's kind of moot at this point, considering that he's been served with revocation paperwork. I know the department, whenever they decide to proceed to revocation, they'll have the hearing, and then they'll let an ALJ decide what's going to happen. But in any event, I think that $5,000 cash is definitely necessary and appropriate. This is an extremely serious case. He has a lengthy history. He's facing significant time on here. This is a Class E felony. I think that that's a really decent and standard bail for this kind of case. So I'd ask the court to adopt the state's recommendation.
Your Honor, can I just add one brief thing? That misdemeanor you talked about from June 4th of 2021 involved two misdemeanors involving his girlfriend, allegedly, that and the girlfriend and he are now back together and have reconciled, and the probation officer had allowed him to see the girlfriend. One of the reasons they had him on the GPS, I'm told, is because he was allowed to see his girlfriend. The girlfriend was going to be the one he was going to go to Illinois with for Valentine's Day. And most noteworthy, he was not revoked for the incidents which formed the basis, allegedly, for the June 4th, 2021 incident, which formed the basis of that criminal complaint. So that's evidence right there. They had a good relationship with his PO.
And Mr. Wagner, I recognize today's not the trial, and we're here talking solely about bail issues. Sometimes the strength of the state's case is an issue that's relevant to figuring out what an appropriate bail would be. I don't know if you wanted to respond to Mr. Eisenberg's observations regarding the strength of the case and the identification issues.
Well, from what I know of this investigation, and again, this isn't my case, that person with those initials that I mentioned earlier, SLB, described the defendant, and her description was confirmed by surveillance video at the McDonald's where this deceased person was found. And additionally, there are all those phone calls in which they were recorded calls from the jail going to numbers that he possessed. So these are numbers that he had used in the past. And she had provided the state with those numbers. So I think there's a connection there, and there was a knowledge, and there's definitely identification. So,
and Okay, but the form of identification is the general description that she provided, and the fact that on 4 or 5 occasions, a jail call is made to the phone number that she provided. And then there's the inference that it's his number based on some of the contents of those calls.
Again, I haven't gone through all of the police reports. I don't know exactly the basis for her description. I'm going off of the attorney's notes that reviewed this case, and that she did confirm that they were able to confirm that it was his identity, and also corroborate it with those additional phone numbers. That it would seem improbable that that she would also have that same information, as well as being able to describe him physically.
I don't think they've confirmed anybody's identity. I think they threw a criminal complaint together. And there's no, at McDonald's surveillance, there's no information that a light-skinned black male was depicted anywhere on video. And if we're going to find that he's responsible because he's a light-skinned black male, and there are probably thousands of those, I find that disturbing.
It does raise another question, and I'm debating how relevant this is, but how relevant it is might depend on the answer. In descriptions of the jail calls, there's a heading entitled Identifying the Defendant. There are a number of calls, I think it's 4, described as occurring on different dates. It's actually 3 calls that are described. I'm trying to figure out whether the ones that say January 5th and January 29th have a typo as to the year, or whether that year is actually correct.
Don't know. You're right. One would think it's December 31st, 2020, wouldn't you?
Well, and January 5th, 2021, and
Which
January
would
29th,
be
2021,
consistent with the dates.
or alternatively, it could be that December 31st, 2021 is correct, and the next 2 should really be 2022.
That I don't know.
Right.
But
I'm hoping Mr. Wagner knows.
Here's what really is concerning. When you read that one paragraph, it looks like JM is the guy in jail. The subject who answers the phone calls, JM, on numerous occasions, subject is also heard talking to some kids in the background. And he says, I'm talking to Uncle Quan. I'm trying to figure out how a guy in jail is talking to kids in the background, because there are no kids in jail. And Quandran Wilson was not in jail on December 31st, 2021. So I can't even make sense of this.
Yeah, I don't read the complaint to say that Mr. Wilson was in jail on these dates, that these were calls initiated from the jail to what the state believes is his phone.
I know.
Yeah.
So there's someone in jail who responds, hey, kids in the background, I'm talking to Uncle Quan, be quiet. How could there be kids in the jail in the background? There are no kids in the jail.
So, Mr. Wagner, maybe you have an answer to the date question.
I would have to review all the discovery, the police reports, to make a determination about whether that was a typo that just got into the criminal complaint, or if there are close to a year difference in the times that the jail calls were made. I would note that in reviewing a ton of police reports as part of my regular job, there are sometimes typos with the dates, and we have to reach out and correct those and confirm that information. And I'm sure that occasionally it does get into the complaint, even though we've had several eyes look at it. Additionally, I mean, making the argument that there's no kids in jail, I mean, he could have just been calling other people kids. I mean, or guys, or whatever. that doesn't
Well, the
necessarily.
word kids isn't
mean-
in quotes. It's implied that the author of either the police report or the complaint
Okay,
perceive them as kids. But I think we've gone kind of far afield, and it's partially at my invitation. So I'll take responsibility for that. Here's how I see this. We'll go back to the beginning and an observation made by Mr. Eisenberg, which is that at present, the bail itself is really academic because whether I gave him a signature bond or $5,000 cash bond or $100 bond, he can't be released until that agent lifts the hold or some resolution of those revocation proceedings. That said, I still have an obligation to deal with the bail issues in this new criminal case, and I'll do that. The focus there is largely on appearance in court and the risk of non-appearance in court. There's been a lot of discussion today about what's most disturbing. I guess what I'm most disturbed by is the fact that this complaint alleges that somebody's dead, that there's a human being who's no longer here. Mr. Wilson's not charged with doing that. Mr. Wilson is charged here with a single count of drug delivery. The specific quantity isn't stated. I can infer that it's a relatively small quantity. Well, I guess this quantity is stated. There's an allegation that it was half a gram, a $60 drug transaction that's described in the complaint. So we're not necessarily, at least based on what's alleged in this complaint, dealing with significant weights or significant amounts of money. We have a complaint that I think is supported by probable cause, but it is circumstantial. I don't know that there's any way to read it that's not circumstantial in nature. And I think I would call the strength of the case here as being moderate at best. I don't know that it's, I would call it weak, but I don't know that it's particularly strong either. There are a number of inferences that have to be drawn in order to put this together with Mr. Wilson. The state's going to make an argument that some of those inferences are reasonable and should be adopted by a jury. I think they're present enough to support probable cause, but whether that's proof beyond a reasonable doubt later on is another question, and it's not one I have to answer today. I talk about it because the strength of the case is relevant to somebody's incentive to miss court. It's relevant to likelihood of conviction. It's therefore also relevant to what could happen in the event of a conviction. I think it's aggravated by the fact that he's alleged to have habitual criminality status. The offense for which he has habitual criminality status is a serious, significant offense, and it's alleged to have occurred while on extended supervision for that offense. So it's made worse in that respect. There are a number of competing arguments here as to what should happen from a bail perspective. I don't see that setting a $100 cash bond is an appropriate response on my part. To me, that just sort of trivializes it all. I'm not going to do that. If I were going to do that, I would just set a signature bond. I'm not going to do that either. I think there's reasons to think that cash bail is necessary to assure appearance in court in this case. I can tell you that if this were charged as a first-degree reckless homicide or something where there was an attribution of the death to Mr. Wilson in a criminally culpable way, I would likely be looking at cash bond amounts that significantly exceed what the state's asking for. He's not charged with that. I have a single drug delivery complaint that does not deal with significant quantities, that is based on inference and circumstantial evidence. I think at most I can set $1,000 cash bail in this case. I'll do that. I'll order as conditions that he not use or possess controlled substances or drug paraphernalia without a valid prescription. I will order that he not have contact with the person with the initials SLB. We're certainly not going to get into the identity of that person here on the record and in the live stream environment, but suffice it to say that there's going to have to be some proof of his knowledge of the identity of that person if there's an effort to charge him with violating it at some point.
Your Honor, I don't want the names listed here. There, will the DA's office, since we're not in court, be sending me the names for those individuals identified by initials? Well, how will I get that, Ben?
It's a good question, and it's one that will have to be addressed at another time. I'm not sure who's providing what information at this point. What I can say is that Mr. Wilson knows he's not to have a contact with a person with the initials SLB. There's probably not that many of people with those initials in his world or any of our worlds. He's also currently in jail, and it sounds like may wind up being there for some period of time. So his ability to make contact with that person should be somewhat constrained anyway. I think it's very difficult to find that he would accidentally have contact with that person.
I'll follow up with their office for the identities. Thank you, Your Honor.
I think that's reasonable, and I'm sure at some point it's going to have to be disclosed. Yep. All right, we'll get a prelim scheduled on a timely basis unless you want otherwise, Mr. Eisenberg.
Your Honor, I would prefer if we could, yes. I'm out of town next week. Could we do a prelim the week of March 7th or March 14th? Would that be permissible? I know the 10-day rule is problematic for me. Can we
Okay,
still-
so it sounds like you're willing to waive the time limits, but you want it scheduled for a prelim rather than a status conference.
Yes, please.
If that's acceptable to the state, I think we can accommodate it.
That's fine.
Thank you.
Yep, well, looks like we're looking at March 11th at 9 o'clock.
That works.
All right, take care. Thank you, counsel, and thank you to Mr. Wilson. Good luck to you.